Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast 132. We're looking at 3 recent cases, of course. One of these days I'll surprise you and do 4. Anyway, this week we've one of the key cases that Miriam and I flagged up during our review at the start of the year on key cases for 2018. Is it direct sex discrimination to pay a woman more for maternity leave than the man is paid for shared parental leave? Secondly, does the issue of adjournments for tribunal hearings where the claimant asserts they are unwell ever trouble you? Well, it certainly does trouble tribunals and employers, and to be honest, I think it can probably prove pretty vexing for employees' advisors and employers' advisors. Anyway, we've got a really useful case in the EAT on the approach to be adopted by tribunals in relation to that issue. And finally, we have a cautionary tale involving Lloyds Bank and a share incentive plan. I mentioned in the last podcast episode the interview which I did on behalf of the Employment Lawyers Association with Judge Brian Doyle. This is going to be out any day now, and I'll do a separate note when that day comes, saying how people can get to hear the podcast. I'd really encourage people to listen to it. Judge Brian Doyle is an excellent interviewee, and it was very informative. As always, don't forget you can access the podcast via iTunes. It's the Mayor Brown website, YouTube, the Twitter feed, Nicholas ROBER11, and that's also where we put out the links, of course, to our cases. So, first up, Capita Customer Management Limited and Ali and others. I mentioned in the introduction this is one of the key cases for 2018. And as I run through the nature of the challenge by the claimant, you'll see why. The claimant is the father of a child. He wished to take shared parental leave on the grounds that his wife was unwell after childbirth. The maternity pay which a woman at the employer would receive was at a higher rate, because it was enhanced by the employer, when compared with the shared parental leave which was paid at a basic statutory rate, which is lower. Here, of course, and as you expect, the shared parental leave, however, is actually paid at the same rate for men and women in the employer. So you have maternity pay, which is enhanced, only women effectively qualify for maternity pay, and then you have shared parental leave, which is capable of being taken by either men or women, but shared parental leave was paid at the same rate for all those on shared parental leave, but it was a lower rate than maternity pay. Was the male employee entitled to claim that if the employer enhanced maternity pay for female employees, then it also had to enhance equivalently shared parental pay for male employees in respect of the same period? The Employment Tribunal agreed with the claimant. At almost the same time, another employment tribunal, Hextall and the Chief Constable of Leicester Police, took the opposite view. So who was right? Well, now we have the EAT decision in Capita, and helpfully, from the point of view of employers at least, and potentially I would suggest from the point of view of women on maternity leave, the answer is that the EAT has come down firmly against the claim that there is direct sex discrimination if shared parental leave is not enhanced equally to maternity pay. According to the EAT judge, the Employment Tribunal had come to the wrong conclusion because it failed to consider the purpose of maternity leave as opposed to shared parental leave. The purpose of maternity leave, according to the EAT, is to look after the health and well-being of a woman during pregnancy, because of course maternity leave usually starts before childbirth, and in the aftermath of childbirth. As such, a male claimant who wanted to care for his child was wanting the leave for a different purpose, which was not sufficiently comparable to maternity leave, with its component of well-being for the woman, to be directly comparable. Moreover, the Equality Act 2010, section 13(6)(b), expressly permitted more favourable treatment in connection with pregnancy or childbirth, and so this is, in my terms in effect, lawfully permitted discrimination in favour of women. In essence, counsel for the employees said that the purpose of the leave for the male employee on shared parental leave and the woman on maternity leave, after the 2-week compulsory period immediately following childbirth, she claimed it was for the same purpose. The claimant submitted there was no material difference between a man on parental leave and a female comparator on maternity leave. The EAT accepted that legislation, both in the UK and Europe, draws a clear distinction between the rights given to pregnant workers and those who have given birth, on the one hand, and the rights given to parents of either sex to take leave to care for their child. The rights are different and the circumstances of those to whom they are given are different. Think of it in these terms. The EAT, in effect, is pointing out that the Employment Tribunal's decision is based on a proposition that the reason a woman was given maternity leave after the first 2 weeks following childbirth is to care for her child. That's not in accordance with legislation, which bases this on the health and safety of pregnant workers, pregnant employees I should say, at work, and health and safety reasons for those who have recently given birth. A woman on maternity leave will no doubt take care of her baby, but that is not the primary purpose of maternity leave. By contrast, the purpose or reason for shared parental leave is for the care of the child, and as such, the direct comparison is not permissible. There are a number of points which come from this decision. First, I suspect it may go further. I suspect this is going to be an appeal case. It's obviously a test case. Secondly, the consequences for employers who had failed to equalise shared parental pay would have been significant if the case had gone the other way. And you could imagine there'd be a number of claims for back pay from those who had taken shared parental leave but suffered in comparison with the pay they would have received on maternity leave. However, perhaps given, I believe, that the take-up for shared parental leave is not great, then maybe this wouldn't be such a big risk. But of course, that slightly begs the question that if employers had levelled up maternity pay and shared parental pay equally, there would have been a greater take-up. You could possibly also have seen people seeking to claim they would have taken shared parental leave but for the apparent disparity of the payments. Anyway, on the current basis, that direct discrimination claim, according to the AT at least, isn't a runner. There are also claims that to enhance maternity pay but not shared parental leave amounts to indirect sex discrimination. Obviously, if you enhance maternity pay but not shared parental leave, then the chances are you're going to have more men receiving less pay in comparison with the women. Obviously, indirect sex discrimination is capable of being justified, whereas generally direct discrimination is not. And this is clearly going to be the next decision in this area of the legislation, and we're going to wait for the EAT's decision on that aspect of the claim shortly. And it's in that context that perhaps the submissions that were made as intervener by the Working Families Organisation are interesting. They studiously avoided supporting either the claimant or the respondent's position in their submissions, but they were keen to make submissions to provide a guide to the legislation. But crucially, they submitted that the EAT, quote, should not reach a conclusion whose unintended consequences lead to a diminution of the rights of the mother or of the parents, unquote. And that, I think, is absolutely critical. Whilst I have no doubt that many employers would accept, if the case went that way, that shared parental pay and maternity pay had to be levelled up. We have a number of clients who've done that already. But equally, I can see a number of employers who would level down benefits so that women on maternity leave would suffer because employers were not prepared to pay parents on shared parental leave at the same rate. We will, of course, cover off the indirect sex discrimination claim when that is reported, which I imagine will be very shortly. So, that's the case of Capita Customer Management Limited and Ali and others. Next up, Leeks and Norfolk and Norwich University Hospital NHS Foundation Trust. As I mentioned in the introduction, the issue of claimants' ill health and adjournments is a problematic one. The EAT has now handed down guidance which I think is going to be very useful for employers and claimants alike as to the approach to take. If you're an advisor representing parties in the tribunal, it's going to be essential to know about this case because of the assistance it offers. The claimant was refused an adjournment to delay a preliminary hearing. There was no dispute that she had various health problems, and indeed her claim related to disability discrimination by virtue of those health problems. There was also no dispute that she was legally disabled in the eyes of the law, but she failed to provide further and better particulars of claim in order to do so by the tribunal, and the Employment Tribunal had also set a date for a preliminary hearing to consider the conduct of the case generally after those particulars had been provided. As I say, the claimant failed to provide the further and better particulars and applied to adjourn the preliminary hearing. This was apparently partly by reason of her own ill health and partly her husband's ill health, and she provided some medical correspondence from the GP to substantiate her health status and therefore her application for an adjournment. Well, the Employment Tribunal took quite a tough line, refused the adjournment because she'd failed to provide sufficient sufficient medical evidence. She applied twice more for adjournments, suggested that perhaps the preliminary hearing could take place by telephone, but this was refused. The respondent then went for broke and applied to strike out her claim, and this was granted by the Employment Tribunal because the claimant had failed to comply with an order and had failed to actively pursue her claim. The EAT commented, when the case got appealed to it, that the issue of claimants and ill health frequently came up as a factor to be considered by employment judges. The EAT said that on a first application to adjourn, the court might be, quote, reluctant, unquote, to refuse an adjournment, but there are other factors to be taken into account by the court, even on a first application. If the adjournment has been sought on medical grounds, the claimant has to provide medical evidence that is, quote, specific, clear, independent and cogent, unquote, and the court has to evaluate that. I think the reference to evidence being independent is quite interesting. Remember here there was evidence from the GP. Equally, we all know that evidence from a claimant's GP is often just a repetition of what the claimant has told the GP, and there's very little independent evaluation. The court also pointed out that, given that someone is accepted as being too ill to attend work, does not necessarily mean they're too ill to attend court. It was appropriate to look at other things. For example, their apparent ability to communicate with the court through correspondence was a factor. I am sure we have all had claimants who are far too ill to work, but can conduct voluminous and highly detailed correspondence very competently with the tribunal. The tribunal can, of course, make reasonable accommodations which justice require for someone who is ill, but this will vary on the particular application, circumstances of the individual's health, etc. The EAT also commented that if it was obvious one party would succeed at the end of the day, then that was a factor in favour of pushing on rather than adjourning. It also accepted that if it was simply a case of a case management decision, then again the court might be more likely to push on with the proceedings rather than adjourning. Finally, the EAT said that the claimant's fundamental rights and freedoms were a factor to be weighed in the balance when exercising a discretion as to whether or not to adjourn a tribunal case, make modifications to tribunal procedure, etc. However, they're only a factor. We've certainly had cases where claimants have apparently viewed the fact their health was giving them difficulties as giving them an absolute right to an adjournment. All in all, I think this case is clearly very helpful for employers. The EAT's factors are going to become some sort of a checklist, which may not have been precisely what was intended by them. Nonetheless, the necessity for independent and cogent evidence of ill health where adjournments are sought is to be welcomed. It may well be that as tribunals are getting busier, they're going to be less sympathetic to claimants who are preventing the effective processing and then disposal of their cases. So that's the case of Leeds and Norfolk and Norwich University Hospital NHS Foundation Trust. Third and final case, Daniels and Lloyds Bank. This is the cautionary tale I promised you. It's about the exercise of a variation clause under a share incentive plan. The two employees who are the claimants in this case worked for Lloyds Bank and they were covered by a share incentive plan. In 2009, they got conditional awards of shares which were due to vest subject to performance conditions. In January and March 2012, they were told that the performance conditions had been met. The court subsequently found that it was at this point that the vesting of the shares occurred. So, vesting of shares, January and March 2012. In February 2012, in accordance with Rule 17 of the plan, the Remuneration Committee for Lloyds decided to alter the rules of the plan itself. They introduced a rule, Rule 6.4, which said that awards could be reduced at the committee's discretion. This was, in effect, a malus clause. There was also Rule 15.7 contained in the scheme, which said that employees could not claim loss in relation to the plan, and that included any loss arising on the exercise of discretion. So, in other words, Lloyds Bank's position was that it was entitled to introduce the malus clause, and to the extent the malus clause caused loss, then the employees were precluded from claiming damages for that loss. The bank then decided not to allow the employees to keep the vested shares on the grounds that they were not willing to run the reputational risk associated with the share awards standing. It was not suggested that either of the individuals had done anything wrong. The claimants asserted that if there was going to be a discretion to reduce awards which are vested, this could only be done on the back of very clear and unambiguous wording. They asserted the wording was not sufficiently clear and the bank was not entitled to reduce the share awards which had vested. The court took the view that Lloyds Bank was not entitled to reduce the awards. The language of the scheme made it appear that there was an entitlement once vesting had happened. Also, the scheme rules appeared to distinguish between the plan and awards made under the plan, and to that extent Rule 6 was not compatible with the bank having a right to alter vested awards. Rule 17, which was the right to vary clause, referred to a right to amend the plan. It did not refer to a right to amending awards. Additionally, Rule 6.4, the malus clause, required dual consideration of the performance of the company and of the participant. The court took the view that the award could not be altered solely by reference to the performance of the company, which is what was being relied on by the bank. Rule 15.7, which purported to preclude any claim for compensation arising from the exercise of discretion, did not operate here. It was focused, according to its terms, on employment claims, not claims in the context of the plan generally. So clearly here there are a number of very specific points related to the drafting which would need to be considered. But I think the overarching point that I would take away from this case is the hostility of the courts to removing benefits that have otherwise been promised to employees in clear language. Here the court appears to have been pretty unsympathetic to Lloyds Bank. Had the wording been completely clear and unambiguous in the plan rules, then it might well have been a different story. But the court was able to find that there were ambiguities, and as such the court was able to choose to find in favour of the employees, who otherwise being deprived of significant benefits which they had a legitimate reason to anticipate would be paid to them once the performance conditions had been declared to have been met. Well, the moral of the story is that if you're going to introduce a malus clause or right to vary clauses or similarly adverse clause to employees during the operation of the scheme, or indeed when setting up the scheme, your drafting has to be crystal clear and needs to contend with a claimant looking to find any ambiguity to enable the court to find in his or her favour. So, that's the case of Daniels and Lloyds Bank. Just remains for me to say thank you very much for listening. The next podcast, we're hoping to do a podcast in about a week's time with Dan Stillitz, QC, on a recent case with which he has been involved in the Court of Appeal to do with age discrimination. And then in a couple of weeks' time we'll have podcast 133. In the meantime, keep an ear out for the Employment Lawyers podcast, and as I say, I'll do a special announcement when that one goes live too. Finally, as I always assure listeners to the podcast, I can confirm that no employees were harmed or otherwise mistreated in the making of this podcast. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.